For I know the plans I have for you, declares the Lord, plans to prosper you and not to harm you, plans to give you a hope and a future. Jeremiah 29:11. Jeffrey and I would like to thank each of you that have liked and shared the previous videos and have subscribed to our channel. You are appreciated more than you know. It is a wonderful feeling to know that others care about you and your freedom. Jeffrey woke in the night with these thoughts about his case, and we will be exploring them and bringing them to light in this video. It is legally called prosecutorial misconduct and ineffective assistance of counsel, but I call it lethal deception because the actions were meant to have lethal consequences against Jeffrey Davis. Much of what is in this video is what we believe took place. We will be examining the articles that lead us to the conclusion that we now have concerning what we believe happened. First, we will examine the laws and rights concerning prosecutorial misconduct and ineffective assistance of counsel. In jurisprudence, prosecutorial misconduct or prosecutorial overreach is an illegal act or failing to act on the part of a prosecutor, especially an attempt to sway the jury to wrongly convict a defendant or to impose a harsher than appropriate punishment. In American federal law, Title 18, Section 1622 provides, whoever procures another to commit any perjury is guilty of subornation of perjury, and shall be fined under this title or imprisoned not more than 5 years or both. The term subordination of perjury further describes the circumstance wherein an attorney at law causes a client to lie under oath or allows another party to lie under oath. In United States law, ineffective assistance of counsel is a claim raised by a convicted criminal defendant asserting that the defendant's legal counsel performed so ineffectively that it deprived the defendant of the constitutional right guaranteed by the Assistance of Counsel Clause of the Sixth Amendment to the United States Constitution. To prove ineffective assistance, a defendant must show 1. That their trial lawyer's performance fell below an objective standard of reasonableness, and 2. A reasonable probability that, for counsel's unprofessional errors, the result of the proceeding would have been different. In Jeffrey Davis's case, the prosecutor knowingly accepted perjured testimony by his co-defendant in his plea and testimony at Jeffrey Davis' trial. This evidence was presented in the previous videos, but we will go over the highlights. The co-defendant testified he was the shooter in Vehicle 1, but not Vehicle 2. His plea stated that after he shot Broomhall, the victim in Vehicle 1, that Jeffrey took the gun and shot into the vehicle as well. However, the victims of that car said there was only one person with a gun that shot into the car that night. Fogelman, the victim of Vehicle 2, identified the co-defendant as the only one with a gun, and he was the one who shot him. He stated Jeffrey Davis was in the background and didn't say or do anything. That contradicts the co-defendant's claims. The prosecutor and judge accepted the plea with no corroborating evidence. In fact, they had contradictions from the victims. The defense counsel did not object to the plea or testimony given by the co-defendant, although he had the preliminary testimony with the victim's conflicting testimony. As you may remember, Jeffrey Davis attempted many times throughout his court dates to fire his attorney, even going as far as writing the bar many times and filing complaints, but the judge would not allow it. He had not hired this attorney, and there is no evidence of him being a public defender. He was also not licensed to practice law when he stepped in as Jeffrey's attorney after his initial defender reclused himself from the trial. No one knows who paid for him to be there. There is no record of the court paying him as a public defender, and he is not acknowledged as a public defender in any of the paperwork. We suspect someone paid him to represent Jeffrey poorly for a guaranteed conviction. The defense counsel and the prosecutor agreed to use the preliminary testimony given by Richard Fogelman, as he was now an out-of-state witness. The February 24, 1992 preliminary hearing was held before Judge Messler, and the current trial was being heard by Judge Dalton. At no time during the At no time during the trial did they discuss the fact that Fogelman stated Jeffrey Davis was in the background and didn't say or do anything, or the fact that he identified the co-defendant as the one and only shooter. If Judge Dalton had been aware of this, he would never have accepted the plea or convicted Jeffrey of these offenses. After Jeffrey's conviction, the defense counsel agreed to a pre-sentence investigation, or PSI. There are blatant lies told in the PSI that neither the prosecutor nor the defense counsel bothered to dispute, such as, Jeffrey pled guilty to the offenses. He never did. Jeffrey's actions were for personal gain. No testimony or evidence of Jeffrey gaining anything from these crimes. In fact, the only one who gained money was the co-defendant, who admitted to snatching the money out of Fogelman's hand. Fogelman testified the one who snatched the money was the one who shot him, and he identified the co-defendant as the shooter. The PSI goes on to say that Jeffrey Davis was identified by the victims, Hicks, Johnson, and Fogelman, as one of the assailants, but were unable to determine who held the gun. But we see in the preliminary testimony that Hicks and Johnson could not identify anyone at all, as it was too dark. Fogelman identified the co-defendant as the one with the gun and the one who shot him and took his money. He only identified Jeffrey as one of the people in the back that didn't say or do anything. The same Judge Dalton who accepted the plea and testimony of the co-defendant months before Jeffrey's trial was the judge who would read these lies before his sentencing. To say he was prejudiced by these lies is an understatement. If you need further evidence that they were set on taking Jeffrey Davis off the streets for good, let's look at the secondary case they brought against him and 3 other co-defendants. He was in the county jail when the secondary case was initiated. The crime was robbery by force, and it took place on or around December 9th of 1991. They would give him the same attorney in both cases, Edward Glass, who he continued to attempt to get removed. They also showed Jeffrey Davis waived his right to jury trial in the secondary case, even though he never did, and there is no evidence he did on the secondary case, only the initial case. Jeffrey Davis would be in court on both the cases, one right after the other, but the secondary case would continue to be postponed until the sentencing of the initial case. When the judge sentenced him to 5 consecutive 50-year sentences, we see the state decided at that point to dismiss the charges of the secondary case on all defendants. We believe they held that case as a backup in case something fell through on the initial case and Jeffrey was able to walk free. They would have it to hold him and try to get a conviction on it. We feel it is also very suspicious that all the case file is transcribed and in the archives leading up to his actual trial dates, and that his judgment and sentencing are transcribed as well as everything following it. The only thing that was never transcribed was Jeffrey's actual trial. We show in previous videos the state's response that Jeffrey Davis' actual trial was never transcribed and has been destroyed and cannot be retrieved. Jeffrey has stated that the co-defendant perjured himself on the stand, but we have no proof of that without the transcripts. We do, however, have the recant affidavit, as well as a written one and many PCR efforts of the co-defendant stating he was coerced and threatened into making the plea, and that if he did not testify against Jeffrey, they would give him another life sentence or the death penalty. We are looking at federal habeas case, but my confidence in filing it is lacking. I do not have the education or knowledge to do it justice. It is our hope and prayer we can find someone to represent him pro bono, or at the least help me to put it together correctly. Again, Jeffrey and I appreciate the support and many prayers that have come our way in this, and would love if you could subscribe, like, and share these videos with anyone and everyone you can think of. Much love to you all, and God bless.